My Lords, if I may, there are 2 points which I'd like to raise. The first relates to the single transaction point which we were discussing yesterday and this morning. Your Lordships have seen examples of the various cases where that's been applied. Those cases are all cases where there have been a number of breaches which have resulted in, on some occasions, monetary loss, and in some occasions, monetary gain. And so one can see that conceptually, in an appropriate case, a set-off may or may not apply, depending on the circumstances. So, for example, in the Brown case, there are monetary losses going both ways, and the majority felt there shouldn't be a set-off in the circumstances. In the Bartlett case, the judge felt there should be. But one can see, because the distinct breach is called monetary loss and monetary gains, it's possible, conceptually, for there to be set-offs. And it's a question of whether they should apply or not. The difficulty with this case is because property rights are created at a certain stage. On any analysis, at stage 3, when the profit is made, so when the hotels are unsold and the money comes in, it's not just, it is a monetary gain, but it's not just a monetary gain. A proprietary right is contained. Property comes into existence. It's our property. And for that reason, we say the normal rules should apply, and it's not appropriate to do, as my learned friend invites the court to do, and to look backwards. In the Bartlett type cases and the Brown type cases, the court was invited not to follow the general rule, but to look backwards across a wider range of transactions, because you could set them off. But here it's different because property rights were created. So it's another reason we said a single transaction, it either it isn't an appropriate way of looking at it, or if it is, it simply shows that it isn't a single transaction. You have to look at the property creation. Otherwise, it drives roughshod through property rights. My Lord, that's my first point. My second and final point was really to come back. My Lord Justice Newey asked whether we are aware of any cases where relief had been sought, equitable compensation against one, where you have a fiduciary and its honest assistant, for example, or an accessory, where an account of profit has been sought against one and equitable compensation against the other. We're not aware of any cases either way. And by either way, I mean, we're not aware of any cases where that was found, but nor are we aware of any cases where it was argued and rejected. We're simply not aware of any cases. But Lord, the reason for that possibly is because what our case isn't, if I say what our case isn't, at stage 3, hotels are sold and money's come in. It's not the case that we're seeking account of profits from Mr. Ruhan for what he made at stage 3 and equitable compensation from Mr. Stevens at that stage. If we had, then there'd be no equitable compensation because there's no loss. It's a distinct breach. So at stage 3, we are seeking against Mr. Ruhan account of profits. It's that breach. The breach against Mr. Stevens is a further breach by Mr. Ruhan. It's there. So we are seeking different remedies, one against one and one against the other. But they're at different stages, different breaches. I'll talk to clarify that. So to go back to the example I used before lunch, Mr. Ruhan makes the £100 million comes in, and we've got an account of profits against him for £100 million. Then a few weeks later, for whatever reason, he asked Mr. Stevens to assist him getting rid of, not all of it, say £20 million, and he assists with that. Our claim against Mr. Stevens is equitable compensation for that £20 million. We still have our account claim against Mr. Ruhan at stage 3, that breach. The second breach, we have our equitable compensation claim only £20 million. I raise that example in a different context to show that they don't always coincide. But it also, they're at different stages, which I thought I should just emphasise. My lords, unless I can assist further, that really is it from me.
I think at one stage you said you were going to make some submissions about what the position on compound interest would be in the event, if it arises, that you lose on the appeal and therefore are claiming the 1.5 million, which would not be equitable compensation, but a claim for Mr. Stevens's own profits, albeit those were not profits which I think were ever subject to a proprietary claim in your hands because they're simply fees paid to him by Mr. Ruhan. I don't know whether that's covered by what you said more generally, or are there any specific points you want to make on that?
My lord, if your lordships are against us on the main point, then we would elect for an account of profits, and there'd be an inquiry as to whatever they are, because there hasn't been an inquiry. I mean, certainly, Mr. Justice Foxton, your lordship may recall, was aware of £1.5 million, but his words were, he's far from satisfied that's the full extent, but that was the monies which were uncovered. Should your lordship be against us on the principal points, there would be an account or an inquiry in the usual way, and we would certainly be seeking at least £1.5 million, but there'd been inquiry.
I see.
And with respect, I'd probably prefer to reserve the position until then, because when the account is given, then there'll be.
Well, when you see what profits there are and where they come from, I suppose, if you get more information, is that what you have?
My lord, yes, because I think it would be, if your lordships are against this side of the court, there would then be a separate. Your lordship wouldn't be replacing the judgment of a particular sum, let alone £1.5 million. We would then have to elect, and I'm sure we would, and there'd then have to be an inquiry, so there'd be further directions, and once the account is then determined, it would be for the determining tribunal there to determine the question of interest.
Thank you.
Mr. Wiggins, just get something off my chest. So I'm looking at the order that Mr. Justice Foxton made.
My lord, yes.
It may be a very short point that doesn't matter, but it's bothering me that the way this order is drafted appears to give you double the money. Assuming everyone complies with the order, and I appreciate that you'll fear partly because they haven't or won't, but the order gives you an account from Mr. Ruhan for 94 million in respect of Kensington, well, in fact, 94 plus 7 million for the two hotels, and then it also gives you equitable compensation against Mr. Stevens. There's nothing in this order which means that the one sets off against the other.
Well, look, we can't double recover. That's absolutely.
Well, I know you can't, but why does the order not stop you from doing that?
If, for example, we received the full sum from one, we'd be precluded from obtaining money from the other.
Okay, well, in that case, it's a drafting problem. As long as it's clear that that is your position. I mean, I'm bound to say at the moment, I don't understand why, for example, if Mr. Ruhan paid all the money, what is it about the order to Mr. Stevens which says he doesn't actually have to pay equitable compensation in the following amounts? But if it is just drafting, then I'm not bothered. I'm still troubled by it, but it's not germane to the issues we have to decide, if that's right.
Perhaps I can just turn my back for one second. Look, that was always accepted, and Mr. Hodge reminds me that we gave an undertaking to the other parties that if we were to recover from one, we would inform the other. So that has been considered. It may not appear, it doesn't appear in the face of the order.
Okay, fair enough. Thank you. The other thing, just a point on the facts, I was trying to figure out in the order, in the judgment, as I understand it, there's no doubt that the HP2, the BSA did complete. In other words, HP2 was paid the whole 127 million.
125 million.
Forgive me, yes, 125. That happened because the bit in the judgment that talks about the sale of the Kensington hotels at that stage out of Cambulo on 320 doesn't condescend into any detail, no doubt, because it wasn't relevant. But presumably, some of those proceeds were used to complete the HB2 transaction. Now, I'm seeing you shaking your heads, and it doesn't matter. The sale, the original BSA, was a complete transaction.
Well, I think that's fine.
Thank you.
Well, yes.
Thank you.
It didn't come for later monies, it came up front. The stakeholders need the money.
I see. Thank you.
Thank you very much.
Just for clarification on the facts, and it's right that £127 million does appear earlier, but there's an adjustment made later on since the net figure. Nothing
I just, before I get myself confused, I'm making note of the point you just made. So £127 million appears earlier, but it's adjusted.
My lord, yes.
Yes.
It's around in the point in the judgment where the on sales of the Kensington hotels are discussed. It explains why there was an adjustment down, and there's a reallocation. The original apportionment, I described it yesterday in my summary as I think it was 56 million towards Lancaster Gate and 69 million to the Kensington hotels. Originally, each of the three hotels had its own apportionment, and that came to £127 million. Later on, various reasons which shouldn't trouble this court, there was an adjustment. It was post the sale of completion, I think, of Lancaster Gate, but there was an adjustment, and the two Kensington hotels were treated together, and the figure was reduced, so it came to the total was 125.
Thank you very much.
I'm grateful. Mr. Ryan it's paragraph 92 of the judgment, which gives that detail.
Thank you. Mr. Garrelson.
My Lord, I'm going to address my learned friend's submissions from yesterday, hopefully in a well-organised way. Then I will address his submissions of this morning, which I'm afraid will not be so well-organised, and I hope you'll indulge me. There may be an element of chaos in how I present these arguments, and I do apologise for that. It's my fault. First of all, my learned friend yesterday spent time on the chronology, dividing the story into 4 stages. He emphasised in particular how much time and effort and complication was involved in what he described as stage 3, which is the exploitation profit stage. His clear purpose in doing that was to support an argument that all that work cannot be seen as part of one transaction, and it was a series of submissions that were plainly designed to support his one transaction argument that he made later. For the moment, it's important to make clear that, as my learned friend very helpfully accepts and fairly accepts, it's clear that stages 1, 2, 3 and 4, or at least stages 2, 3 and 4, he included the acquisition of the hotels and Mr. Ruhan becoming a director, but the real stages 2, 3 and 4, he fairly accepted it was a single course of conduct for a single purpose. That purpose was not just the acquisition of the hotels. In fact, that acquisition was just a means to an end. The purpose was to allow Mr. Ruhan to exploit the development opportunities in these hotels for himself and to apply the profits from that exploitation in his other ventures. The fact that turning them to a profit and using the profit could be said to involve different stages, or if intellectually one wished to organise them that way, in my submission is neither here nor there. It's what one would expect with a series of several hotels whose development was bound to be complicated. It doesn't matter how or when planning permission was obtained, for example. It doesn't matter how or when the profit was made, because the plan was always that profit would be made. And it doesn't matter in my submission how and when the profit was spent, because the profit was always going to be spent. That was the whole point. These are just matters of detail, and in my respectful submission, they don't detract from the clear analysis of the substance of the matter. Lord, just to make that point good, it's worth looking at my learned friend's own pleaded case. I'll go very quickly. It's the core bundle behind divider 12. If I could pick it up very quickly at page 267. For your Lordship's note, paragraphs 30 and 34 set up or rather explain the setting up of the probe. Perhaps we should go to that very quickly. If I could invite your Lordships to go to page 263 and have a quick look at paragraph 30. The background is that Mr. Ruhan ceased to be the entire owner of HP2. He became diluted. And then if we move forward to page 265, we see that at paragraph 34, that the Cambulo group was set up in anticipation of HP2's restructuring. And then and if your Lordships were also to look at paragraph 33, and there's the anticipation. I'm so sorry, I gave your Lordships the wrong, the wrong paragraph number. 264, paragraph 33. Move forward to the next page, paragraph 37, 37.1 and 2. What that makes clear that the opportunity to develop the hotels was an opportunity of significant value, and that Mr. Ruhan diverted this opportunity away from HB2 and to its creditors to Cambulo as his nominee. If one moves forward to page 267, can I invite your Lordships to read paragraph 40? So why was the Cambulo sale procured? It was procured with the intention of diverting the opportunity away from HP2 and its creditors so that it could be exploited by Cambulo as his nominee, i.e. for him. And if one goes forward, if I'm going too fast, please tell me, to page 270. Paragraph 45.1. Again, we see that the Cambulo group was created for the sole purpose of holding and exploiting the opportunity. And perhaps the scheme finds its clearest voice at page 292. This is paragraph 76, paragraph 76 being the paragraph in which a breach of his fiduciary duties is alleged. That's at page 291. If one looks at particulars, and in particular one looks at subparagraph 3 at the bottom of page 292, so why was the arrangement set up and maintained? Answer, so that Mr. Ruhan would be in a position to make gains without having to account to HB2, whereby he would be able to exploit HP2's trust property to further his own private ends and ventures. So there's an explicit reference there to the fact that his purpose was to use the profits when he made them in his other business interests. My lords, that was the claim which was upheld by the judge. One can see that the judge upheld it from the whole of Section D of the learned judge's judgment. I'm sorry that there isn't a single paragraph which pithily makes the point. But it was upheld, and it was a process. The process that he upheld took several years to carry into effect. There is one point of detail that may be worth averting your lordships to. Your lordships may remember yesterday being told by Mr. Pickering that the proceeds of the Cambulo sale of the 2 Kensington hotels were used to pay down what was called a mood facility. And that mood facility had been taken out previously to fund an investment in Qatar. Lord, I advert, it's a point of detail, but it is illustrative in that it shows that the application of the profits in the Qatar project, and the arrangements were being made for that application even before the profits were made. Such it would be unreal and artificial to attempt to distinguish between the making of the profit and the application of the profit. That's not what this case is about. So that's my submission on the 3 stages relied upon by my learned friend. Second point I'd like to address is my learned friend's point.
Meaning we can put away the pleading.
You can put away the pleading, absolutely. My learned friend said, and he made the fair point, that there's no finding as to what would have happened had Mr. Ruhan complied with his fiduciary duties. Lord, however, that's, if I may say so, and this is a rather profound point, it was not the claimant's case that they would have been in a better position had he complied with his duties. The court, therefore, was not required to decide what would have happened. Now, what happens in that situation? Does the court proceed upon the basis that it would have been different, in the absence of a finding that the company's position would have been different? That question was answered in Gwemba Valley. And if I could go very quickly, it's addressed in some paragraphs which my learned friend took you to this morning. It's in
Mr. Pickering accepted that, didn't he, when I asked him?
I think he did, my lord. Perhaps I'm over egging my pudding. Your lordship has the point. I'll just state the references. Your lordship's quite right. One of the grounds of appeal that was run in Gwemba Valley was that, as a matter of principle, where there's a suggestion that a loss has been made as a result of a breach of fiduciary duty, and the errant fiduciary wishes to escape liability because there was no loss, the errant fiduciary bears the burden of proving that things would have been the same. And if he fails to do that, presumptions are naturally made against him. Lord, that was a submission that was rejected. That was a submission that was rejected at first instance, and the judge simply found that the claimant had failed to discharge the ordinary burden of proof that claimants are under to prove their loss. And the Court of Appeal, at paragraph 159, upheld the judge's approach. But as your lordship's quite right, perhaps I'm repeating a point that doesn't need to be repeated. The third point I'd like to address with your lordships is a question that was raised during argument yesterday afternoon. I think we're agreed, my learned friend and I, that it doesn't matter for the purposes of this appeal, but it may well matter for the purposes of the way that you express your analysis when writing your judgment, and nobody wants to say something that turns out to be wrong when it's avoidable. Lord, whether the custodial breach, which my learned friend relies upon, the key question is whether the custodial breach, which my learned friend relies upon as being separate and distinct, is bound up in, so inextricably connected with the original fiduciary breach, that it would be manifestly unjust, artificial, and unreal to allow cherry picking. That it doesn't matter whether the breach, the original fiduciary breach, is seen as a breach which results in a proprietary claim in the hotel, which can then be traced into the profits, or whether it's seen as a breach which gives rise to a liability to account in relation to which there is then a constructive trust. Either way, the connection is just as intimate and just as inextricable. It's worth mentioning, however, and I'm not going to invite your lordships to go to the pleading, that the pleaded claim was that Mr. Ruhan was liable to account for his profits. And for your lordship's note, that's paragraph 77 of the particulars at page 293 of the bundle. And also in the prayer, your lordships will see it. A sort of declaration.
Paragraph 77 and the prayer. And
the prayer, paragraph 1H and paragraph 2, that's at pages 304 and 305. And Lord, that was a claim that was upheld by the judge in paragraph 342 of his judgment, which is in the core bundle at page 271. It's in fact paragraph 342, Roman 1. Lord, it was suggested that I may have accepted during my submissions that in fact there was a tracing claim through the hotels. I wasn't aware that I had accepted that. I'm not blaming my learned friend, perhaps I did.
So your position is you accepted there was an institutional trust at the stage when the profits had come in?
Yes, I did. My submissions were focused on the profits claim. Given the concern and the interest your lordship showed to the point, overnight my learned juniors and I have put together a note and put together some authorities that your lordships may find helpful. Could I hand them up?
Yes, please. And Mr. Pickering has seen this, presumably?
He was set it this morning before the hearing started. We have copies of all the authorities referred to in the note, but these are the ones which I was proposing to take your lordships to, should you be interested. But as I say, if you'd like all the authorities, we can provide them.
Let me just glance through briefly, but
yes.
I suspect, as you say, you don't need to go into all the detail. That's helpful. Thank you very much.
Lord, if that analysis is right, it does leave both the reasoning and the result in J.J. Harrison as being puzzling.
When I was reading down this a bit, I saw that someone suggested that the explanation must lie in the idea that somehow or other the transactions were unauthorised. I must say, on the basis the transactions were unauthorised. It's not absolutely clear how.
Well, there's still but even if that's true, there's still the problem that the transfer was made pursuant to a contract involving consideration. So there's still a need for rescission. And Lord, interestingly, the first instance judge did consider this point, but Lord Justice Chadwick appears not to have done. I don't know if your Lordship would like to look at it now, but for your Lordship's note, the relevant pages where the judge below came to the conclusion that because there hadn't been, I may be oversimplifying, there hadn't been rescission, so all that was available was an account of profits. That's at page 1191, paragraphs 54 to 59. Lord, secondly, another point that your Lordship may wish to bear in mind is that the price that was paid pursuant to that contract was £8,400. And Lord Justice Chadwick, at the end of his judgment, page 1207 of the bundle, he indicates that that purchase price should be credited against the defendant's liability under the constructive trust. So he did take the price into account, but what he didn't do is consider the juridical basis upon which he should do so. That one would have thought that the net result is it's effectively an account of profits backed by a constructive trust. So it may be there's no difference between the result in J.J. Harrison and his I should say no difference in the result between his analysis and an ordinary orthodox account for loss of profits analysis. The result may well have been the same.
Yes.
But I hope that assists.
Yeah, it is helpful, thank you.
If I could then deal fourthly with some other authorities that were addressed by my learned friend yesterday. First of all, he referred to Paragon. In my submission, his submissions didn't add anything in relation to which I need to deal with. Then he dealt with Foskett in the context of questions from the bench as to the rescission problem, and he sought to suggest that Foskett may provide an answer. Foskett was a case of misappropriation of company funds. The trustee helped himself to money from the trust account and used that money to pay some insurance premiums for himself. And if your Lordships were to read the judgment, which I'm sure you have, you'll see that it's all on the basis of misappropriation. There's no consideration of, and that case has no bearing on the question whether the hotels were held on constructive trust before the profits were made. Well, then my learned friend took you to Gwemba Valley, and he went back to Gwemba Valley this morning. I'm not sure that it's necessary to address that case in as much length as he did, but perhaps I can make a couple of points. Perhaps we could go to the case. It's behind Divider 1 in Volume 4. The first point I should make is that in our skeleton argument, we submitted that if HB2 were right, then the court couldn't have made the order it actually made in Gwemba Valley. And my learned friend addressed that claim in his submissions this morning. I hope your Lordships will recall that during my submissions, I sought to make it clear that that submission was wrong, and I rode back from it in as dignified a manner as I could. And the point that I wanted to make was a more subtle one. And could I make the point by reference to the judgment? Could I ask the court to go to page 1279? Now, just background, the allegation was that Mr. Koshy had, as a director of GVDC, procured the company enter into some transactions with a company in which Mr. Koshy had a substantial shareholding called Lasco. And the complaint was that that contract, the procurement, involved a breach of fiduciary duty. And what the claimant wanted was it wanted its money back, the money that it had paid under that transaction. Now, it's important to note that originally in the proceedings, the related company, the company called Lasco, was actually a defendant. And a claim was made that Lasco held all the payments that it had received from the company pursuant to these transactions on constructive trust for the company. My Lord, an application for summary judgment was made on that claim, and that application was upheld. And could I ask your Lordships to read paragraph 6? The summary judgment order against Mr. Koshy was set aside, but the order against Lasco never was. So stopping there, the result was that before they even set foot in court for the beginning of the trial, Lasco was a constructive trustee of all the payments that GVDC had paid to it. So they held the very money in relation to which GVDC wanted to be compensated by Mr. Koshy. If we move on to page 1282, we'll see what happened to Lasco. It's paragraph 18. If your Lordships could read that very quickly.
Sorry, which paragraph?
Paragraph 18, page 1282. So what had happened was that GVDC had paid over money, had been procured to pay over monies by Mr. Koshy in breach of his fiduciary duties as a director. Those monies had been received by Lasco as constructive trustee for the company. And then Mr. Koshy, in his capacity as the controller of Lasco, had allowed Lasco to dissipate the monies so that Lasco was no longer worth powder and shot. The court will see at once a clear analogy between the position that applied in Gwemba Valley and the position that my learned friend says applies here. Breach of fiduciary duties, creating profits, which the fiduciary then causes to be dissipated, which are held on constructive trust, but which the fiduciary then causes to be dissipated in breach of the custodial duty.
You say cause to be dissipated. Do we see that?
Not in that paragraph, not. I have to go back into the judgment. But Lasco, it wasn't wholly owned by Mr. Koshy, but it was substantially owned by Mr. Koshy. I forget. There'll be a paragraph somewhere dealing with it, maybe in the court below, but I could look at that. And
so you're dealing with Mr. Koshy's role, are you? But do we know it dissipated anything?
I'm so sorry?
What's the evidence that Lasco dissipated money?
Well, it's gone into liquidation. It hasn't got the money anymore. It's gone.
Could have been the cost of litigation. I don't know.
Well, the only point I make, Mr. In relation to this is that the situations are strikingly similar. Yet it never occurred to the claimants, who were trying their damnedest to get their money back. It never occurred to them to make a claim of the sort that my learned friend is now making with Mr. Justice Foxton's encouragement. Lord, I'm informed by my learned juniors that Mr. Justice Reimer in the court below had said that the money had gone, but that may not entirely answer your lordship's question.
Yes, I see.
But this was no holds barred litigation, and might have thought if the claim worked, it might have been articulated. I put the point no higher than that. Lord, fifthly, I'd like to say a few words about my learned friend's submission that he was talking about £94 million number, but it can be applied to the entire 102 million profit figure. That was real money, and the loss of that money was obviously a loss. I accept the rhetorical power of that point, but it completely misses the point that's taken on this appeal. In my respectful submission, as a result of the decisions I spent a day taking your lordships to, the comparison to be made is not how the account stood the minute before the payment was made out and the minute after the payment was made out. The counterfactual is the position before the original fiduciary duty was breached in the first place. Or more strictly, what the position would have been had there been compliance with the fiduciary duty in the first place. That is the comparison that has to be made. Position at time T1 after the money's gone, and the position at time T0 before there is any entitlement to money in the first place. And that's why I say, if one applies the right counterfactual, or you can talk about set-off, you can talk about credits, they're all different ways of grappling with the same thing, one ends up with the inevitable conclusion there has actually been no loss. That brings me to what my learned friend accepted was the key point in this appeal, whether it is appropriate to choose that as the right counterfactual, whether it's appropriate that T0 involves there having been no breach of the original fiduciary duty. And my learned friend very fairly accepted that it's possible, depending on the application of the rules, that if the two breaches could not be treated as distinct in the specialised sense in which I use that word, then it would be appropriate to take those two counterfactuals. His argument was that, in fact, the custodial breach was on its own a distinct breach. Now, in order to make that submission good, he started by taking your lordships to Underhill, which I'd already taken you to, and on the basis of the passage in Underhill, he suggested that the test for distinct breaches was the one transaction test. And he spent some time yesterday afternoon trying to explain why his stages 2, 3, and 4 couldn't be, in any sense of the word, be described as one transaction. I was slightly confused this morning because if I heard him correctly, I believed he said one transaction was just a phrase used by Underhill. And in fact, it's not a phrase that's to be found in any of the cases. In my submission, he's right about that. But that's by the by. We've already seen Underhill. What is clear is, even if Underhill were a statutory provision requiring construction, requiring interpretation, when the phrase one transaction is used, it doesn't mean one transaction in the nominalistic sense, in the very strict technical sense. It doesn't even mean a single course of conduct involving numerous events or actions. It means breaches of duty which are so inextricably connected that it would be unfair, unjust, and unreasonable to consider the one without taking the other into account. It's a shorthand phrase to describe that fact pattern. And if one looks at the authorities that Underhill itself relies upon for the proposition, They're Bartlett and Hulbert, the two cases that we've seen. Taking Bartlett, first of all, we don't need to go to it. I'm sure your lordships are now well familiar. The transactions in that case were completely different. The profitable transaction had commenced in 1961 with the purchase of a development property in Guildford. The disastrous Old Bailey transaction was commenced in the early 1970s, and it went disastrously wrong at or around the time of the 1974 property crash. So they couldn't have been further divided in time. I believe it's fair to say that the Guildford project was sold much later, much closer in time, but that's not the point in my respectful submission. The point is they were clearly, on any view of the word, separate transactions in the literal nominalistic sense. Now, why then, I ask rhetorically, does Mr. Justice Brightman decide not to consider the loss suffered as a result of the one transaction without considering the gain made as a result of the other? Not because whether they're the same it's nothing to do with transaction terminology. It's because the two transactions stemmed from the same policy, the same. Mr. Justice Brightman also described it as the same investment. I think he said the same folly. And part of the proceeds of the first transaction were used in the investment in the second transaction. Now, on any view of my submission, that means course of conduct. It doesn't mean one transaction. We then come to the second case that Underhill relies upon, the Hulbert case. It's at volume 4, tab 40. We don't need to go to it again. Your lordships will recollect. That involved two breaches. First of all, a breach in failing to pay capital gains tax when it ought to have been paid, thereby subjecting the trust to penalty liabilities. And then a further breach by using some of the trust assets to pay off some of the penalties. And when it was suggested you can't do that, we want full compensation, not only for all of the penalties, including compensation for the fact that some of the penalties have now been paid off using trust assets. The defence was, well, hold on, we made the payment out of trust assets because the particular assets we paid were interest that had accrued on the trust as a direct result of our not having paid the CGT in the first place. That was not, these two breaches and the two sets of payments were not one transaction. Interestingly, this was a clear misapplication case, incidentally, which would have been susceptible to a substituted performance analysis if substituted performance made the slightest bit of difference, which of course, in my submission, it didn't. There were separate breaches using trust assets to pay part of the penalties, or separate breaches, one allowing the penalties to be accrued, the other allowing trust assets to be used in their discharge. The reason why the judge allowed credit to be given was not because they were all part of one transaction, far from it. In fact, the latter breach was part of the steps taken designed to remedy the former breach. It's because the breaches were inextricably connected. To use the language of Lord Brandon in Bank of Boston, Connecticut, and European Grain and Shipping, it's discussed in the Geldof case that I showed your lordships yesterday. It's an equitable set-off case, and before anyone says anything, I'm not suggesting it should be the same test. By no means should it be the same test. It's a different situation, but I think I'm allowed to say it's isomorphic. The latter claim flows out of and is inseparably connected with the original breach. I then come to Brown and KMR Services. Could we have a quick look at that? Your lordships will remember, contract case, a series of insurance policies covering each year. There were a series of breaches for each year. The claimants were allowed to cherry pick the years that went into loss and ignore the years that went into profit. I won't trouble your lordships with the dissent. You've already seen it. But if we could go to Lord Justice Hobhouse's judgment at page 640. kernel of his reasoning starts at letter F, about halfway down the page. Mr. Brown is entitled to sue in respect of each distinct cause of action. Each cause of action gives rise to a right in law to recover the damages which the plaintiff has suffered by reason of the breach which constitutes that cause of action. The cause of action is a legal one arising under contract and is not dependent upon any equitable or restitutionary principle, see Westdeutsche. Stopping there, why does Lord Justice Hobhouse feel the need to say this doesn't raise any equitable principle? My respectful submission, it's because he's building an argument that whatever approach may have been adopted by Mr. Justice Brightman in that pesky equity court, this is a legal course of action and falls to be subject to a proper common law approach. And if one reads on, it was not an action for an account. Same point. He's saying we're not in a court of equity here. We're not considering the liability of the fiduciary or other accounting party for breaches and so on. We're just talking about legal breaches, well, common law breaches of contracts. Although there was an element of repetition in the defendant's breaches, it was not a case of a continuing breach. So there, his lordship might be saying, perhaps I'm placing too much weight on those words, perhaps he's saying this can't be seen as a continuing course of conduct. But I may be doing too much fairness to my case by saying that. And then if we go over the page to page 641, picking it up at letter C, Lord Justice Stuart Smith, with whom I have the misfortune to disagree on this point, has referred to the case of Bartlett, in which Mr. Justice Brightman allowed a set-off. He then describes the facts, and he then very fairly summarises or quotes the critical point. Mr. Justice Brightman observed that part of the profits from the company's successful speculation had been used to finance the unsuccessful speculation, adding, I think it would be unjust to deprive the trustee of this element of salvage in the course of assessing the cost of the shipwreck. And then he says this, the principle applied by Mr. Justice Brightman arose from the context of that particular case. It cannot, in my judgment, properly be applied to the legal remedies being enforced in the present case. Well, stopping there, Lord Justice Hobhouse is not suggesting that Mr. Justice Brightman was wrong. And to be fair, my learned friend doesn't suggest that Mr. Justice Brightman was wrong. He simply says that there are differences between the present case and that case, with the result that I'm not going to do what he did. So I ask rhetorically, what are the differences? What is the context of the particular case which justifies the decision in Bartlett and yet justifies the decision in Brown and KMR Services? Answer, in my submission, because Brown and KMR Services was a case that it operated entirely at law. And I'm really conscious of doing what Professor Worthington points out should not be done, which is if you add the word equitable to everything, then somehow the judge starts sitting under a palm tree. I'm not saying that. But I do say that the principles at work in this case are equitable. These are claims made against fiduciaries and claims made against dishonest assistants. The source of their liability is doctrines of equity that were invented over periods of hundreds of years. And equitable principles should determine how their liability works out in these kind of cases. So I respectfully submit that Lord Justice Hobhouse was right to think that the context of an equitable case is very different from the context of Brown and KMR Services. Those are my well-organised submissions. I'm now going to try and be coherent. Could I start with a submission that my learned friend made this morning? Yes, it's a submission my learned friend made about paragraph 286 of the learned judge's judgment. Could we go back to the judgment? It's in the core bundle at page 196. It's just to be clear, in this judgment, I would respectfully submit, the judge, first of all, indicated that he would adopt the separate breach analysis. He did so without considering the requirement that the breach be distinct as well as separate. There is nothing in his lordship's judgment which will assist this court in answering that question. I'm afraid the inquiry has to be made by this court without the assistance of submissions from, of guidance from the learned judge. The judge then gave 3 reasons for his conclusion. These are not reasons why he took the view that the breaches were not distinct. He never even asked himself that question. They're reasons for thinking it appropriate to adopt the separate breach analysis. The first one is the adoption point, which, as I say, I apprehend was the judge grappling towards the notion that you are allowed to start the clock halfway through, because by the process of adoption, you're somehow extinguishing the original liability. So at that point, of course, all that's left is the ultimate liability, and both the fiduciary and the dishonest assistant can be liable for that. Lord, he makes the point in his last sentence. He says it can be argued that if the beneficiary takes this course, then there can be no dishonest assistance in respect of acts of the fiduciary which are so adopted, leaving only such breaches as the beneficiary does not choose to adopt, which can be the subject of a claim in dishonest assistance. Now, his words, "it can be argued," are worth noting. He's not actually saying that's the legal result. Lord, that's my first submission. My second submission is that the argument is wrong. As I gave as my example when I addressed your lordships on this the other day, imagine a situation where the claimant decides he elects for the remedy of an account of profits against the fiduciary. That doesn't stop him from electing the remedy of an account of profits against the dishonest assistant. Why should it, I ask rhetorically? Now, my Lord Justice Newey asked whether my learned friend was aware of any case in which an account of profits had been elected for as against the fiduciary, and equitable compensation had been elected for as against the dishonest assistants in respect of the same breach. My learned friend wasn't aware of such a case, and nor am I, or vice versa. Lord, that's my first submission on this morning's submissions. My second submission is in relation to paragraph 287. It's simply to note a point that was apparently accepted by my learned friend. This is where my learned friend indicated that I had submitted, I did submit, that where an earlier, on the basis of Group 7, if an assister assists the initial making of the profit, then that also counts as the assistance for the ultimate dissipation of the profit. My learned friend did not submit that I was wrong about that. He simply said that he reserved his position, and that is worth noting in my submission. Third point. Yes. When pressed on why is it that the breaches in this case aren't really distinct, having retreated somewhat, I don't mean to be discourteous to my learned friend, but having retreated somewhat from the Underhill one transaction way of looking at the case, he then alighted upon as a separate justification the fact that this was a case of fraud. So he's suggesting that whatever the rule might ordinarily be, where it's fraud, the court should apply a strict nominalistic rule. In other words, the distinction between a separate cause of action and a distinct cause of action collapses to nothing. All separate cause of action, I think his submission must be, ipso facto become distinct causes of action by virtue of their being formally separate. Lord, I have a number of responses to that. First of all, the analogy with equitable set-off. in an equitable set-off situation, any cross-claim that satisfy the requirement of being sufficiently closely connected and it being manifestly unjust to consider the one without the other, any cross-claim can fall within the doctrine of equitable set-off. There is no exception for fraud claims based on fraud. And nor should there be. What would be the justification? That brings me to my second submission, which is that the only justification that I can think of is that fraudsters are bad uns and they should be punished for their wrongdoing. Lord, there are more statements than I can shake a stick at. I'm being too informal, I do apologise. But there is no shortage in the authorities for statements by judges that in decisions being made on equitable compensation and indeed compound interest, the court doesn't seek to punish wrongdoers. We had that being said by Lord Denning in Wallace, Steiner and Moy in the context of compound interest. We had Mr. Justice Lewison saying that in Ultraframe, and I believe that statement of Mr. Justice Lewison's is cited by my Lord Justice Birss in Lifestyle Equities. I'm afraid I don't have it to hand. But in my submission, it's obviously right. You don't treat a person who's acting dishonestly differently. You don't apply different substantive rules to them. In determining what loss their actions have caused, you apply the same rules that you would apply to someone who committed a wrongdoing, a breach that isn't constituted by dishonesty. And Lord, there is a hint, perhaps this is my third submission on the fraud exception. There is a hint of a similar argument being advanced in Auden Mackenzie. Perhaps we can look at that. It's in Bundle 7. It's at tab 51. It's paragraph 63, which is at page... is it 51? No, it's paragraph 63, which is at page 269. 2691, I'm so sorry. This is the judgment of Lord Justice David Richards. And he says, Mr. George also submitted that if Mr. Patel could rely on his proposed defence, it would enable a dishonest director who in effect steals money from the company to escape without redress. This consideration echoes what was said by Lord Toulson in AIB, that the principle underlying the decision applied absent fraud, which might give rise to other public policy considerations. That would be the submission that my learned friend would be making in this context. And he said, the possibility of a fraud exception has been criticised, and then there's a reference to Lewin. It does not seem to accord with principle that equitable compensation should be payable only because the defendant has acted dishonestly. Lord, I say that's obviously right. I could now move on to my next submission. I've now got to my learned friend's substitutive performance submissions. A number of points. The first point is that the premise, the starting point for all his submissions on substitutive performance is that in the case of where the claim could be seen as a claim for substitutive compensation, there is a more stringent test of liability. He said, counterfactuals fall away. As I say, that's the premise upon which the rest of his argument from which the rest of his argument follows. The premise is wrong in my submission. It is absolutely not the case that counterfactuals fall away. That was the ratio of the House of Lords in Target, and it was the ratio of of the Supreme Court in AIB. In AIB, is an even stronger case, because there the counterfactual was a hypothetical counterfactual. Your lordships will remember the facts. The solicitors had received the mortgage monies, ready to pay it over to the mortgagee of the vendor. By mistake, the solicitors only paid off part of the mortgagee's mortgage, with the result that when the transaction completed, the lender found itself subordinated to a first mortgage in favour of Barclays. The counterfactual question which the Supreme Court held had to be asked in order to determine liability for that breach was what would have happened if the full amount of money had been paid to Barclays, thereby discharging its mortgage. So not only was it a case where a counterfactual question was asked, it was a case where it was a hypothetical counterfactual. In Target, if your lordships will recall, I've now forgotten, the mortgage came in late, but it did come in. So it was a matter of looking to see, okay, the mortgage should have come in earlier, it should have come in before we advanced the mortgage monies, but we've got it now, no harm done. So it could be seen as looking to see what happened once the mortgage monies have been paid out and what should be given credit for. So you could see Target, if you wanted to be strict about it, you could see Target as simply a sort of historical crediting and debiting process. But with AIB, it was completely different. With AIB, they had to ask themselves, what would hypothetically the position have been if this thing which didn't happen had happened? So it's a graphic example in my submission of the proposition that I seek to urge on your lordships, that counterfactuals absolutely don't fall away where you're articulating a claim which you could describe as a substitutive performance claim. The question arising in this case is what is included in the counterfactual that you have to apply. And your lordships will now be well aware that my submission is that question is answered by reference to the principles to be derived from Bartlett and Hulbert and that line of cases. Well, the next submission I'd like to deal with is a series of submissions that my learned friend made about a case that he himself relied upon in his skeleton argument, the case of Davis and Ford. It may be helpful to remind the court what the facts were in that case. The essential complaint was that the director of the company had diverted a maturing business opportunity of the company. I think my recollection is to do with a waste management plant. And rather than, which the company had started pursuing, but then rather than pursuing it for the company, he had diverted that opportunity to a company that he owned. And the question was what compensation in equity should be paid for that diversion. And it was in that context that the court had to decide which approach, whether to adopt a reparative or a substitutive approach to compensation. The learned deputy judge, David Holland, QC, I should say, decided that it was a reparative compensation case. And he decided that because what had been diverted was not existing property of the company, but it was a developing business opportunity. That was the judgment, which was then appealed to the Court of Appeal, and which Lord Justice Henderson described in the Court of Appeal as impeccable. That part of the judgment was described, the reasoning was described as impeccable. So there is authority from this court that in situations where what's being diverted is a maturing business opportunity, for example, a development opportunity, then one approaches the case as a reparative rather than a substitutive compensation case. it was relied upon by my learned friend in his skeleton argument, but to my surprise this morning, he appeared to be submitting that it was wrong. Before we get to the question whether it was wrong, I would like to make one point clear. I say the substitutive reparative distinction has absolutely no bearing on this case at all, and your lordships will already understand why. I say that even in a substitutive compensation case, there still has to be a counterfactual applied, because it's still necessary for the court to be making an award which is compensating a company or a beneficiary for loss that it has actually suffered. I question, it would be going too far to say that the entire distinction is of no utility. That it does point up some factual differences between a substitutive claim and a reparative claim, but the differences of principle are very limited, if indeed they exist.
Going off to tangent, supposing in Bartlett each claim had been substitutive rather than reparative, would it have made any difference?
Not the slightest bit of difference. Indeed, I'm glad your lordship asked me that question, because it reminds me that in his consequentials judgment, Mr. Justice Brightman described himself as giving restitution to the trust fund. Perhaps it's worth looking at that. Is it tab 8? It's behind divider. It's behind tab 8 in bundle 1. Lord, it's at page 260 of the bundle. At letter C, in my judgment, the defendant is seeking to introduce a distinction which is not justified. As was pointed out by the plaintiff's counsel, the obligation of a defaulting trustee is essentially that of effecting restitution to the trust estate, see Underhill, where there's a useful quotation from the judgment of the Australian case in Re Dawson. Your lordship will have seen Re Dawson cited in Target and in AIB. It's a well-known case in this rising in this context. Until restitution has been made, the default continues because it has not been made good. For example, if there were 2 settled shares in a trust fund, part of which has been lost in breach of trust, the measure of default is, in my opinion, precisely the same in each case, notwithstanding that one settled share has vested absolutely a month or a year or 5 years before the default is made good, unless the person absolutely entitled has, by virtue of his absolute entitlement, in some way lessened the responsibility of the trustees. Well, stopping there, I don't want to go too high or make too much of this point. This was a case where the claim was for breach of the duty of skill and care. On the authorities as they stand now, this is a paradigm example of a reparative claim. But these clever arguments of characterization that with which we now have to deal were only invented in the last 25 years or so. Back in the day, in the 70s, the people didn't think like that. People thought about the trustee's primary obligation as being one to restore the trust fund. And that's how Mr. Justice Brightman conceptualized the case. And it is, in my submission, quite interesting that the example that he chooses to give is the example of a misappropriation case. I venture to suggest, I put it no higher than that, but I do suggest that had this case not been a case against the trustees for failing to supervise the directors of the trust company adequately, but had the trustees been the directors themselves, and had they made unauthorized investments from the company, the outcome of this case would have been exactly the same. But that would have been, as my learned friend would have it, a substitutive case. That's one of the reasons why I respectfully submit that the substitutive reparative distinction, although it may have a role to play in other cases, in my submission, this is not one of them. If I could return to Davis and Ford. Oh, yes. As I say, my learned friend tried to suggest that the case was wrong, even though the approach has been upheld by Lord Justice Henderson in the Court of Appeal. He did so because he recognised the difficulty that the breach involved in this case would plainly be reparative. And what he was trying to do, I think, if I understood him correctly, and I may be doing him an injustice here, I think he was trying to suggest that where you commit a breach, which ends up creating a trust fund, in this case, a liability to account for profits, which is then held subject to a constructive trust, that represents, I'm not sure I understood but I think it's something like that represents future property. And Mr. Holland was wrong to say that the substitutive approach only applies to existing property. It applies to future property also. Well, Lord Davis and Ford, and in the Court of Appeal, is authority for the opposite conclusion. In any event, your Lordship already has the point. I think at one point my learned friend suggested that if Davis and Ford were wrong, that would shortcut or short circuit the distinct breach inquiry. I'm not sure that was where his argument was going. It may be that he was suggesting that even if you treated the two breaches together, because you can conceptualize the first breach as a substitutive breach, then his substitutive argument still works. The premise of that argument is wrong, in my submission. But even if it were right, your Lordship already has my submission, that it would be the same. This is not a case which depends upon the outcome of the substitutive reparative distinction. Your Lordship, my Lord Justice Newey pointed out what I think may be a typographical error in Lord Justice Henderson's judgment. Perhaps we look at it very briefly. I don't want to take time on a relatively small point. It's in the bundles at tab 53, which must be
it's file 8.
Bundle 8. And it's at page 286. 2869, paragraph 131. There's a discussion of FHR, the case which finally makes it clear that Lister and Stubbs has gone. And he says, halfway down paragraph 131, bribes and the taking of secret commissions are persistent scourges of commercial life which fully justify the most stringent remedies against agents who take them. But it by no means follows that the same principles should be translated in their entirety to the generality of cases where compensation is sought from an erring fiduciary. In such cases, as it seems to me, the right approach is that the principal may seek a substitutive remedy in respect of existing trust property, which is misapplied by the agent, or an account of profits made by the agent. Stopping there, relatively uncontroversial proposition of law, but that if the principal elects not to seek an account of profits, he should be confined to a reparative remedy compensating him for any actual loss caused. In my submission, that doesn't make sense. You make a claim either for a substitutive award or for an account of profits. You elect against the account of profits, and you end up making a reparative claim. I think there may be a typo in that. I think what happened, he says in paragraph 132, in my judgment, this is in substance the position in the present case. What happened in the present case was that the claimant made a claim for a substitutive award, having elected against an account of profits. The judge below held that he wasn't entitled to a substitute award, he was only entitled to a reparative one. And that's what he got. And I think that last paragraph, that last sentence in paragraph 131, may be a rather unfortunate way of describing that process. Next submission, I'm hoping it's my 6th submission on today's argument, is the discussion about Bell's indenture. This was a discussion of the coextensive principle, the principle that my learned friend seeks to promenade at various points in his argument, that where a fiduciary is liable for X pounds for his breach of fiduciary duty, and there is a dishonest assistant, it follows as night follows day that the fiduciary, that the dishonest assistant will be jointly and severally liable for X pounds. Now, invariably, that will be the result. But in my submission, the true principle is that where a fiduciary is sued for breach of fiduciary duty, the court makes a calculation of the loss that's due from him in accordance with proper principles. In other words, it determines the loss which flows from his breach of fiduciary duty in accordance with the principles that are applicable to him. And where a court is called upon to decide a claim for dishonest assistance, it is also called upon to determine the loss flowing from the breach of fiduciary duty which was assisted. But when making that determination, it has to apply the principles that are applicable to that dishonest assistant. 999 times out of 1,000, the principles will be the same. That doesn't mean, however, that they will always be the same. For example, what may count as distinct breaches as between the beneficiary and the fiduciary may be different when one considers that question from the perspective of the dishonest assistant. There's been no case which has ever grappled with that question. All the cases will talk generally about joint and several liability. They talk about accessory liability. I'm not suggesting that there's any great case that I can rely on in support of this proposition, but in my respectful submission, it follows as a matter of principle. It would be a rare case where different principles would determine how one is to calculate the loss caused by the relevant breach of fiduciary duty. But it is theoretically possible, and where it is possible, in my submission, the dishonest assistant should be liable by reference to the principles that are applicable to him, not by reference to the principles that are applicable to the fiduciary.
I have to say at the moment, we'll reread all this stuff and maybe it'll all become clear to me, but at the moment I'm not entirely clear in every respect how the claim against a fiduciary and the claim against a dishonest sister relate to each other. I mean, you touched earlier on the what the position might be where an account of profits is claimed against one and the compensation is claimed against the other, and so on.
Yes.
And this is sort of the same territory. I mean, how far is the claim against a dishonest assister reflective of and parasitic on a claim against a fiduciary?
Lord, that's right, and I'm not aware of any case which grapples with that question in the way that you've raised it. I would suggest, though, respectfully suggest, if one goes back to Royal Brunei and Tan, Lord Nichols talks about secondary liability and then refers to the phrase, or for want of a better word, accessory liability. It's quite amusing because, of course, the later cases seem to treat the word accessory as having some kind of magic consequence because it's used in the criminal context. I do respectfully suggest that might be a slightly unwise way of approaching his language. In any event, his speech wasn't a statute. The fact that A is liable for something and B is secondarily liable, it doesn't necessarily follow that B is liable in exactly the same amount. And the only example I can give you on the authorities, I'm afraid, is the example provided by Novoship. and it's in relation to an account of profits, not in relation to loss. But what novership shows is that although the dishonest assistant has accessory or secondary liability in respect of the fiduciary's breach, he's not liable for the same profits that the fiduciary is liable for. He's liable for his own profits. So there's an example of an exception to the coextensive principle, which I'm sure academics probably call it. There must be books in which that phrase is gleefully used. Those are my submissions. I can only make brief ones. They have no support other than novership itself, which I appreciate could be said to represent an entirely different context. Lord, I believe this is the eighth point. My learned friend was addressing Group 7, which is in Volume 7 at tab 49. And he suggested that in Group 7, an argument which was similar to the argument I'm running was rejected by this court. I don't want to take too much time, but may I just very briefly go to that case? It's Volume 7 at tab 49. It's page 2505. I'm looking completely on the corner. So sorry. 2505. That was a case in which your lordship may recall that an assistant had assisted in persuading a solicitor, a firm of solicitors, to accept a company as a client so as to enable the company to pay funds into the solicitor account. The funds having been paid into the solicitor account, the company then gave instructions for the payment out of those funds to the fraudster standing behind the company. It was held that the instructions to give the payment out was a breach of fiduciary duty. And the solicitor was held to have dishonestly assisted that breach of fiduciary duty, even though the solicitor had done nothing to help the giving of the instructions or the accept. All he'd done is he'd helped the solicitor agree to accept the company as a client. And your lordship will recall my submissions about the significance of that. The solicitor, in the course of, the solicitor appealed from the determination of liability and ran a number of arguments, including that there'd been a break in the chain of causation because of another dishonest assistance intervention and so on, all of which were rejected. One of the arguments that were rejected was that Grupo Torres shouldn't be followed and that the proper measure of the dishonest assistance liability in the modern world was that the assister should be liable for the loss his assistance caused. So it was a full frontal attack on the Grupo Torres approach. And that attack was rejected. And it's rejected, your lordship will see the basis of the rejection in subparagraph 2, which is on the letter F at page 2506, which may be over the page. There, the judgment of the court made clear, it's made clear by Target and AIB that there's no warrant for introducing common law concepts into this area of law in the manner proposed by the appellants. What must be shown is that the conduct assisted the breach of trust and that but for the breach of trust, the loss would not have occurred. The statements, oh, I'm so sorry. I've actually misled your lordships. Can I go back and correct myself? The argument was that instead of applying, it was accepted that the dishonest assistant was liable for the loss caused by the breach of fiduciary duty. But the argument was that in assessing what loss was caused, one should apply common law causation rather than the equitable type causation, if I can put it that way. And the difference being that in the common law, you're allowed to say, I'm only liable for those losses of which I am the effective cause, whereas in equity, in certain contexts, you're allowed to say, the claimant's allowed to say, I am entitled to be compensated for all the losses suffered on a but-for basis. The most obvious distinction between those two forms of causation would be where Mr. A gives Mr. B an opportunity to suffer loss at the hands of Mr. C. In the common law basis, that would not be held to have been caused, because Mr. A's creation of the opportunity would not be seen as the effective cause of Mr. B's loss, whereas in equity, it perhaps would be. And it was that was the sort of difference that the solicitor, that the appellant was trying to invoke in this case. And what the Court of Appeal said was, no, Grupo Torres makes it clear that we apply equitable principles to the causation of loss. And if you look at Target and you look at AIB, there's no warrant for introducing concepts of effective cause. It's simple but for. And that's that. The appellant sought to rely upon novoship, because in novoship, this court had applied common law notions of causation to the liability to account for the dishonest assistance profits. And that attempt was rejected very robustly. And the last 3 lines of subparagraph 2, the statements in novoship arose in a different context of a claim for an account of profits and do not assist the appellants in the present circumstances. Now, my learned friends suggest that that demonstrates that this court has held that in all circumstances and for all purposes, the equitable rules of causation must apply to any assessment of loss. But actually, properly understood, it's only a statement that that is the appropriate approach to adopt in the present circumstances.
110.1, they say, on authority, 2 stages. It must be shown that the conduct in fact assisted the breach and that the loss directly resulted from the breach. And then they say the test at the second stage is that the loss in fact resulted from the breach of trust.
Yes.
Does that not help Mr. Pickering?
I'm sorry, I don't understand your lordship's question.
No, we'll keep going and let's see whether anything emerges.
I'm more or less finished. If you're expecting something to emerge, I'm slightly worried. The point is that that flowing directly is but for causation. But for causation comes from Target Holdings and Redferns and from AIB. It's applied in subparagraph 2. The attempt had been made was to introduce a notion of effective cause. The real cause wasn't the fact that the solicitor's account was open. The real cause was the fact that the director gave the instructions to the solicitor. That was the effective cause. And the court said, don't be silly. In the present circumstances, we're applying the traditional equitable rules. My learned friend says, well, that covers this case. A similar argument was run and it's been rejected by this court, so you should reject it too. I say the argument was quite rightly rejected on the fact that in the present circumstances, of that case, the circumstances in this case are completely different. And I advert your lordships to my alternative argument made on my second ground of appeal. If all else fails, I respectfully submit that because of the principle established in novoship, that a dishonest assistant should only be liable for his profits and should only be liable for those profits after the exercise of a discretion. And in determining what profits he's liable for, one applies common law rules of causation. Because that's the principle established by novoship, if there is to be a claim which has the result in making a dishonest assistant liable for a fiduciary's profits through Mr. Justice Foxton's 2 breach analysis.
Well, he of course says he's not making you liable for the profits; he's making you
yes, of course.
For the property.
Yes, he does. But my submission to this court is that if the substantive effect is that, then it would only be right to apply common law causes of causation. That's my alternative argument on ground 2. I'm sorry I didn't present that quite as clearly as I would have liked. Lord, next point, and flowing directly from this point, my learned friend referred to paragraph 293 at page 198 of the judgment. Could we have a very brief look at that? This is a submission he made on the basis of Miss Justice Foxton's judgment. On my alternative argument on ground 2, if your lordships aren't with me with my full-blown novership argument, my fallback novership argument is at the very least you ought to apply novership causation to a claim for what is in effect the fiduciary's profits. My learned friend sought to rely on paragraph 293 as suggesting that if that is the test of causation, it's been satisfied. So could I invite your lordship to read paragraph 293 down to the end of Roman 2. What the learned judge was saying there is whether you apply common law or equitable causation to the connection between the breach and the loss, that causation test is satisfied. But that is to misunderstand the causation argument I'm running, and I now fear that I may not have articulated it properly just now. Let's pretend I did. I'm now properly articulating it. It's that the necessary causal connection is not between the breach and the loss, it's between the assistance and the loss. And I'm very sorry for not having made that clearer before I should have done. And the judge didn't address that question. He didn't ask himself the question, if did Mr. Stevens's assistance, did that constitute the effective cause of this loss, or would the money have been lost anyway? Did it merely give Ruhan the opportunity to spirit the assets away? And in circumstances, of course, where Cambulo was holding these assets as nominee for Mr. Ruhan in the first place, it would be a surprising result in my submission if the court were to find that in actual fact Mr. Stevens' intervention was the effective cause of the loss. Now, I'm afraid I've meandered around a little bit in circles with these submissions, and I do apologise. They will marry up now. The final version will marry up with what I said yesterday. But I'm terribly sorry for not having made myself clearer today. But I hope it's clear now. Lord, would your lordship give me a moment?
Certainly.
Finally, let me come to compound interest. My learned friend had, to my immense relief, a very simple submission on compound interest, which means I can deal with it quickly. However, how convinced you'll be by the way I deal with it is another question. He essentially said that the question of the availability of compound interest is determined not by the jurisdiction of the court to award compound interest, not by the authorities governing the jurisdiction of the court to award compound interest, but by the accessory principle. He says that just as the errant fiduciary is liable for a given measure of loss, so must the dishonest assistant be liable for that loss. And if the dishonest assistant is liable for the same measure of loss as the fiduciary, well, then it follows that the dishonest assistant must also be subject to the same compound interest liability as the fiduciary. Lord, I say that's confused. I say that the jurisdiction to award compound interest is entirely separate from the jurisdiction to award equitable compensation, first of all. Secondly, I say the principles governing the two jurisdictions are different. Putting it in more direct language, the principles governing the assessment of loss for the purposes of an award of equitable compensation are not the principles governing the availability and award of compound interest. They're just different things. And I say, and perhaps I could give an example demonstrating this fundamental fact. Merely because someone is subject to the same measure of loss, is liable for the same measure of loss as a fiduciary, as someone else, doesn't mean it's appropriate to make the same interest award against them. And perhaps I could do that by reference to Black and Davis. Your Lordships will recall in Black and Davis that was the case in 2005, where there was a rather nice attempt made to persuade this court to extend the first of Lord Brandon's two circumstances in which interest can be awarded, the fraud circumstance, to extend it a little. Lord Brandon's case one for compound interest was where money had been obtained and retained by reason of fraud. And the claimant in that case hadn't, I should say the defendant in that case, hadn't obtained and retained money by reason of fraud. He'd committed a fraud which had resulted in the claimant suffering loss. But the loss suffered by the claimant wasn't attributable to any money that the defendant had obtained. And it was argued that, well, that doesn't matter because what they mean is there's been fraud. If there's been fraud, then there's the ability to grant compound interest. And this court gave short shrift to that argument. And they said, no, the two cases in which interest can be, these are the two cases, and you're outside it, and there we are. But the reason why I mention it is because what that shows is if you imagine a situation where there's a conspiracy involving all sorts of wrongdoing, including deceit, but also unlawful interference, breach of contract, you name it, all the conspirators would be liable for the same amount. They'd be liable in solido as conspirators. One of those conspirators might be a fraudster who has obtained and withheld money as a result of his fraud. Against that fraudster, it would be possible to make an award of compound interest. But it would not be possible to make such an award against his fellow conspirators, even though they have the same liability, even though their liability might be said to be accessory to his. And what that demonstrates is a point I've now made in three different ways, that the award of the rules relating to the award of the measure of compensation are just different from the rules relating to the award of compound interest. And to the extent my learned friend seeks to say, well, it's the same measure of loss, therefore it must be the same kind of interest, that won't get him a get out of jail free card. There is no passport around Westdeutsche Landesbank in that convenient way. Now, I don't know whether I can assist your lordships further. Oh, would your lordship give me, I'm so sorry. I'm reminded, my Lord Justice Mayles asked me as to whether I had anything to say about the rate of interest. Should your lordships be minded to overturn the learned judge's decision as to the award of compound interest? Do I have any submissions to make about whether it should still be 2.5%, this time simple?
Well, it's 2.5 over base, isn't it?
I'm so sorry, you're quite right. 2.5 over base.
Period, that may not make much difference.
Well, you may have just have answered my question. I was going to suggest 2%, but I was going to do so in a very quick way and then be quiet and sit down. There was one other point, actually, rather more substance. My learned friend indicated that if I'm successful on either my first or my second ground, with the result that the equitable compensation award goes, what should happen about compound? Should you still make a decision about compound interest because it might be relevant to the profits that Mr. Stevens made? And my learned friend, I think, invited you just to kick that question off for another argument. Lord, bearing in mind that this court has heard full argument, and bearing in mind you have my submission that the same principles govern the award of interest in relation to Mr. Stevens's profits, as would govern the award of interest in relation to his liability for equitable compensation. It would be extremely convenient. It would save an enormous amount of time and costs if your lordship were to decide all these questions now. And now I can say, unless your lordships have any further questions.
We don't seem to. So thank you very much, Mr. Garrobinson. Thank you to all counsel, those who have had speaking parts and those who haven't, and also to those instructing them for wide-ranging, interesting, difficult arguments. It won't surprise you to know that we will reserve our judgment in accordance with what is now the practice. They will be delivered remotely rather than in a courtroom. Again, in accordance with normal practice, you will be supplied in advance with drafts for you to correct our typing in English, but not to re-argue the case. And we would ask you to seek to agree an order dealing with consequential matters. If there are points on which you disagree, we would be grateful for brief written submissions, and we would expect to settle the points in the order that we make. You, of course, will have well in mind the confidentiality attaching to draft judgments. I imagine you also have well in mind the particular emphasis that has been placed on the importance of abiding by those recently in this court, and we would ask you to have that duty very well in mind when you do indeed receive the drafts. But that apart,